Hello everyone. We have already seen that public law can be classified under three heads: constitutional law, administrative law, and criminal law. In the last two presentations, we have dealt with the importance and scope of constitutional law and the administrative law. This presentation will give an idea about the scope of criminal law and why it's important for a society to have a just and rational criminal law. We all know that the first and the basic instinct of man is self preservation. This gave rise to the feeling of revenge, and the revenge led to retaliation. If this were the only instinct, it would have led to the end of the world because the weak and then the strong would have become victims of the brute force employed for self preservation. But the nature, while guaranteeing preservation, did not ignore or overlook the perpetuation of species and thus introduced a desire for procreation, that is, multiplication of its species in all living beings. Thus, there was a natural transition in the primitive society from individual to family and from family to state. In the beginning stages of human progress, there was very little appreciation of criminal responsibility. In the first stage, individual was primarily concerned with self-preservation. In the second stage, family was concerned with protection of family from foreign attacks. If there was a quarrel between the members of the family, the head of the family resolved it amicably. But the head of the family could not exercise any control beyond his family. Thus, there arose a need to evolve a device to bring a number of families together, and this led to the development of clans, and law appeared in its rudimentary form. Thus, societies developed. Penal law in the beginning was not law dealing with crimes but only law of wrongs. Acts which caused harm to others were considered wrongs, and the wrongdoer was proceeded against by the person suffering the wrong. The wronged recovered compensation for the harm suffered from the wrongdoer. A very few acts were considered harmful to the well-being of the society, which should be noticed and punished. There was no systematic trial regarding these acts, and criminal jurisprudence had a very small beginning. There were no complex rules of criminal liability. Number of crimes were limited. The person causing the harm had to pay compensation to the person suffering the harm in the form of bought. In addition to this, in some cases, fine had to be paid to the king in the form of white because the act caused disturbance to public peace. Killing was justifiable in certain cases like execution of death sentence. In this stage, there was no distinction between a tort and a crime. Administrators of justice intended to maintain public order by providing simple legal remedies instead of resorting to self-help or blood feud. There was no proper machinery for investigation of crimes, and penalties imposed did not vary according to the mental attitude of the wrongdoer. Penalty awarded was nothing more than pecuniary compensation to the injured party. This period was called the period of strict liability, wherein mental element was irrelevant in crime. The function of law was supposed to be only to regulate compensation to be paid to the wronged and the fine to be paid to the king, and not to punish the wrongdoer. Gradually, it was realized that in order to maintain peace and order in the society by securing the life and liberty and property of the members of the society, crimes have to be prevented, and this could be done only by deterring the wrongdoer from committing crime by inflicting punishment to the wrongdoer. When infliction of punishment to the wrongdoer was thought necessary for curtailing criminal acts, it became necessary to fix the quantum of punishment to be awarded, which in turn had to depend upon the mental attitude or wickedness of the offender's mind. Thus developed the modern criminal law, wherein acts of commission or omission, which would be crimes, would be specifically defined and punishments would be provided for such crimes. The main aim of criminal law is to protect the life, liberty, and property of individuals of society by maintaining law and order. Protection against all injuries that human conduct can inflict on individuals and institutions can be ensured by an effective system of criminal justice administration, and therefore criminal law of a society is of utmost importance. If the criminal law is weak, the society disintegrates, and if it is harsh and arbitrary, it results in injustice to those who are caught in its web. Penal laws have therefore to be rational and just. So far as India is concerned, general penal law is contained in the Indian Penal Code, which came into force in 1862. It contains 511 sections divided into 23 chapters, which contain principles of liability, definitions of specific offences, and punishments for these offences. Whenever a person is accused of an offence, the direct consequence would be deprivation of liberty by arrest and confinement. Ignorance or mistake of law is not an excuse according to law, and hence he cannot plead that he was ignorant of any law of the country in general and criminal law in particular. Hence, a general idea of the provisions of the general penal law is a must for every citizen of this country. Thank you.